Hello and good morning, everyone. My name is Kek Roys, Vice President of Healthcare Risk with Bender Insurance Solutions. I've been with Bender for over 12 years, and I'm thrilled that Bender provides this educational seminar to our clients and friends. We want to welcome you to another educational BenderU webinar. This title of this webinar is New Employment Laws for 2026. Some housekeeping notes. If you have any questions during the webinar, please feel free to type them into the Q&A section. We'd like this to be an interactive experience, so our presenter will be available to answer your questions in real time throughout the webinar. During our additional Q&A time at the end of the presentation, I will be sharing other questions you might have for our speaker. We want to be conscious of time, so if we don't get to answer all of your questions, we will gladly reach out to you individually after the webinar. If you are in listen only mode and will remain muted throughout today's session. This session is being recorded. At the conclusion of the webinar, the recording link, as well as the copy of the slide deck, will be forwarded to you. We have an incredible expert sharing with us this morning, and to introduce him, I'm thrilled to introduce Krogh Decker. Derek is a partner and attorney at Krogh Decker, LLP. He has been practicing law for over 21 years and has defended and advised employers continuously throughout his career. Derek has experience with defending state and federal employment lawsuits, class action, and PAGA matters, and actions brought against employers at the Labor Commission's U.S. Department of Labor, California Civil Rights Division, EDD, and the U.S. Equal Employment Opportunity Commission. He regularly advises and counsels clients on a multitude of legal actions and issues and helps guide businesses through the complicated maze that constitutes California and U.S. employment laws. Derek, take it away.
Thank you, Kek, very much. I hope everybody's doing okay. Thank you for taking this time this morning. I think this will be hopefully educational and maybe a little bit exciting at times. As we're going through, if anybody has any questions, you can raise them, and Kek will pose that question to me as we're going along. Some of this stuff can get a little dense, and so if you need clarification or an explanation on any of it, please let us know. And if anybody can't hear me for any reason, please let Kek know. This is the 2026 California Labor Law Employment Update. I do want to start out by saying the fact that everybody's here is the right thing to do. Our firm represents clients on a lot of different employment issues, as well as guides them through matters that hopefully avoid liability. And California's not stopping with employment laws. They keep putting them out every year. You have federal laws that are coming out every year as well. That is not going to stop. And these are a real area of liability for companies, depending on the claim involved. They can be very damaging to a company from a financial perspective, a time perspective, and an emotional perspective. So the best defense, the best planning for any employment issue is being proactive, understanding what the laws say, and anticipating where the problems might arise. So the first issue is a minimum wage increase. This is pretty simple. Effective January 1st next year, minimum wage is going to increase to $16.90 an hour from $16.50. The one thing to note is if you have employees at your company that are in an exempt position, an executive or managerial exemption, administrative, something like that, that requires the payment of 2 times minimum wage or something like that, in order to have a valid exemption, that will obviously increase that amount as well. So check those employees out, make sure that they haven't fallen below the required compensation rate, because if they do, that exemption will disappear, and then all the issues with breaks and overtime and whatever might apply under the specific wage order will be a concern. Also note that local jurisdictions may have increased rates. For example, San Francisco, 19.18 an hour. Payroll should obviously be updated for any minimum wage positions. Like I said, examine the exempt positions, make sure they meet that salary test. Review wage postings and notices. The next issue is Senate Bill 294. This is the Workplace Know Your Rights Act. Employers are now required to provide a standalone written notice to each current employee of certain workers' rights on or before February 1st of 2026 and annually every year thereafter. This notice has to have information about workers' compensation benefits, notices related to inspections conducted by an immigration agency, protection against unfair immigration-related practices, the right to organize a union or engage in concerted activity in the workplace, and constitutional rights when interacting with law enforcement at the workplace. There will be a template notice available January 1st, 2026. You can get this on the Labor Commissioner's website. This should be a relatively easy thing to make copies of, put it in employee onboarding packets, and also distribute it to current employees. The notice must be provided in a manner the employer normally uses to communicate employment-related information. Again, it must be provided to a new employee upon hire. One thing I would say for this issue and really for any other employment policies or matters, if you have people in the workforce, employees that do not speak English or English is not their primary language, and it perhaps could be a difficulty at times with reading and writing things, especially legal related documents, have them translated into their native language. That is a good thing, an advisable thing to do for any kind of a written policy. Under this Workplace Know Your Rights Act, employers also have to let employees have the opportunity to name an emergency contact by March 30th of next year and at the time of hiring for new employees. So this should be something that should be obtained in writing from employees. I am assuming that the template notice that is provided by the Labor Commissioner next year may have a space for this information to be able to be entered. If it doesn't, the information should be obtained in writing, and the employees have to be allowed to indicate whether this emergency contact should be notified if the employee is arrested or detained on the work site during work hours or during performance of the employee's job duties, not on the work site, if the employer, so if the company has actual knowledge of this arrest or detention. Senate Bill 513, the next issue up, is an addition to the personnel files for employees. And before going into this, I will say that, yep. Mm-hmm.
A question: what are the consequences if we don't have these notices up or policies in our employee handbook?
Yeah, so it's a really good question, and it's probably a good question for a lot of the things we're going to cover. For this specific Senate bill, for this specific law, there's not, from at least in the language so far, it's going to have to be finalized, but there's no language in the law saying that an employee can expressly sue based on the inability or the failure to put that notice up, provide that notice, and go over it with employees. The issue becomes really for that notice, and for a lot of other things where there's not necessarily an express right to bring a lawsuit or a claim, the issue becomes, does that somehow weaken the company or create further liability for some other issue, right? If there was a lawsuit and anything that was in the notice was an issue for that lawsuit in some way, and I will say broadly, we're a defense firm. Plaintiffs' counsel firms will look for any angle they can get to strengthen their claims. That works both ways. But if there's something in that notice and it wasn't provided and it's relevant to a legal claim or a lawsuit, you can be sure that a plaintiff's counsel will try to rely on that and use it, right? The message is, or the communication is, hey, this employer does not care about employees. They are not giving them required notices that the law says they have to. And because of that, it created confusion on these issues, and these issues are relevant to this lawsuit. That's kind of how it plays out for things where, again, the law doesn't expressly allow you to sue. So Senate Bill 513, this is additions to the personnel file. Personnel files don't have a 100% clear statutory definition about what is in a personnel file, right? But there are certain things you have to include a personnel file, anything you're relying upon for an employment action, discipline, termination, things like that, all of the required immigration forms, things like that, right? So this Senate bill is expanding the Labor Code 1198.5, which deals with personnel files, to also include any education or training records. So employers who maintain any kind of education or training records must make them available to employees and ensure that they include the following: the name of the employee, the name of the training provider, duration and date of the training, core competencies of the training, including skills and equipment or software, and the resulting certification or qualification. So in most cases, a good example would be this: the required sexual harassment training that employees and specifically managers also have to go through. Those records should be kept in a personnel file. This, as it's written, is fairly broad, so any kind of education or training records should be kept in the personnel file. Senate Bill 617 is the WARN Act revision. So you may have heard of the WARN Act. There is a California and a federal law that requires certain employers in certain situations, if they're going to do what's considered a mass layoff or a mass termination, to provide certain notices to employees prior to that happening. So this law is going to require written notice, again, for a mass layoff, relocation, or termination, which already is current law. It also is going to have to include information on whether the employer plans to coordinate services through the local workforce development board or another entity, along with a statement about local workforce development boards, information regarding CalFresh, the statewide food assistance program, and a functioning email and telephone number of the employer. Relatively simple. It's not an incredibly burdensome addition to the current laws. I would say for any company that is doing a layoff or termination of sufficient amount of employees, and they think that the WARN Act is going to apply, consult with an attorney, because the danger of not complying with that law is all of those employees could be held to be improperly terminated. There are notices that need to go out before that kind of an action takes place. Assembly Bill 692 is the no, stay, or pay contracts. So this generally, stay or pay contracts, the idea is an employer has an agreement with employees that in some way financially penalizes them if they're going to leave, right? Broadly, at a broad level. This is being put under the Business and Profession Code. It's 16608. It will prohibit any contracts entered into on or after January 1st, 2026 from including a term that does any of the following: requires a worker to pay an employer, training provider, or debt collector for a debt if the worker's employment or work relationship with a specific employer terminates. Authorizes the employer, training provider, or debt collector to resume or initiate collection of or end forbearance on a debt if the worker's employment or work relationship with a specific employer terminates. Or imposes any penalty, fee, or cost, excuse me, on a worker if the worker's employment or work relationship with the employer terminates. Any contract or contract term that violates this section is going to be void as contrary to public policy. So you're not going to be able to enforce them, is what it means. Now, there are exceptions to this law for certain contracts, which would include the first one: a contract entered into under any loan repayment assistance program or forgiveness program provided by a federal, state, or local government agency; a contract related to the repayment of the cost of tuition for a transferable credit that meets specific requirements listed under that section. Let me get rid of this. Sorry about that. Whoops. I apologize. There we go. And the third would be a contract related to enrollment in an apprenticeship program approved by the Division of Apprenticeship Standard. And a contract for the receipt of a discretionary or unearned monetary payment, including a financial bonus at the outset, so the start of employment, that is not tied to job performance, provided that certain specific conditions under that statute are met, and a contract related to the lease, financing, or purchase of residential property, right? Looking at the law as it is and the exceptions, there is not going to be an exception if a employer gives an employee a loan that says, hey, if you quit, you have to pay it back immediately, right? It doesn't mean that you can't give a loan to an employee and seek repayment on it. It just cannot be tied to, if you leave, you have to repay it. What it is, yeah.
We have another question come in.
Mhm.
We currently keep a training binder for all trainings held for our employees, which include all the required information per SB 513. Do we need to move these documents to each employee's file, or can they be kept in our training binder and distributed to employees upon request?
My recollection of the statute is, I don't know that's 100% clear on mandating that, current existing training records have to be transferred into, take them out and split them up into the applicable personnel files. That's my recollection of it. I'm happy to look into that further. What I would say, though, also as well is it's a good idea to do that anyway. And the reason being is, one, it keeps it organized, it keeps it specific to that employee, and there are employment issues that come up where it's important to be able to show those things. And so if a personnel file is going to be inspected or it's going to be put out for production, my general take on personnel files is sometimes there's things you want to withhold, if you're allowed to legally, right? There are certain specific things, after consultation with counsel, that you might want to not include in the personnel file if you have grounds to do so. That being said, in the vast majority of cases, the more information you have for an employee, the more production of files you have, usually it's for the better. So I would generally say, because the law is not 100% clear on having to, pull the existing training records and put them in the files, I would say, unless it's an undue burden, do it anyway.
Should this also include investigation files in the employee's personnel file?
Yes, generally. Again, I've had clients where they say, hey, we have these records. Is this something we're going to have to produce? We have a letter from an attorney representing the employee, and they want the personnel file. We don't think we want to produce this, right? That's a specific discussion. It doesn't come up all that often. But if you're talking about an investigation file, and that investigation file had in any way to do with the reason why the employee left the company, it has to be under the labor code. It has to be in the personnel file, right? So clear example, if somebody was investigated for some kind of harassment and there's witness statements showing that the person probably did commit harassment, those have got to be in the personnel file. And the conversation I've had with clients sometimes is, well, we don't want to expose these other employees, right? This person wrote a confidential written statement regarding what happened, and we're concerned about letting that person's name out. I will say, the law operates in gray, right? So there are certain occasions where perhaps after consultation with counsel, because of, let's say, a threat of ongoing continuing harassment of the person that wrote the statement, there may be a privacy objection. But in general, yes, the labor code requires documents relating to any disciplinary or termination or layoff decisions to be included in the file. And ultimately, at the end of the day, if it is a legal matter, certainly if it's a lawsuit, that information is going to have to be produced anyway. So my advice generally to employers is, it's going to come out at some point, and if you don't produce it now, and it's produced later, it's going to look like it's being hidden. You know, that's kind of the nitty gritty of what it gets into.
We've had lots of questions come in, Derek. Sorry.
Yep, no worries.
Question regarding AB 692. Does this apply to hiring bonuses and requiring them to stay for XXX months?
Potentially, yeah. So the slide we're on, actually, number 4 is, again, it doesn't apply to a contract for a discretionary or unearned monetary payment. So a bonus at the start of employment, if it's not tied to specific job performance, right? So if it's just, here's a signing bonus, if it's a true discretionary or unearned monetary payment, right? It's just money that they're being offered without anything tied to it. That contract would be exempted under subsection 4 that we're looking at here. Now, if the bonus is, you know, hey, if you meet these requirements within the first 6 months, we're going to give you this bonus, or we're going to give you a bonus at the start and it's contingent upon you showing XYZ, that is very likely, that is something that's going to be barred.
Additional question on around this. We have a number of loans to employees. If we terminate them or they quit, can we force them to pay it back at time of termination?
If it falls within the language of what this statute is and none of the exceptions apply, then you're not going to be able. Again, it's not an issue of not being able to recover. I want to make that clear, right? The employer can recover. It just cannot be tied to, it can't be tied to the leaving, right? If you leave, you got to give us the whole 50,000 back immediately, you know. But it also, by the statute, these are only for contracts that are entered into on or after January of next year. So if you got a contract now, by the language of this, what will be a statute, that this law does not apply to previous contracts. All right, I'm going to go on, and just stop me if I'm moving too quick or there's questions on any of it. Senate Bill 642 is payment of wages. This is Labor Code 432.3, which is currently in law. It requires employers to include in a job posting the pay scale for the position. I think most people are familiar with this. If there's an online posting, a newspaper posting for a job, whatever it is, you've got to provide the pay scale. You know, this position pays, you know, XYZ per hour to XYZ per hour, something like that. Currently the term pay scale is defined as the salary or hourly wage range that the employer reasonably expects to pay for the position. This statute will amend the definition to a good faith estimate of the salary or hourly wage range that the employer reasonably expects to pay for the position upon hire, right? And I think the concern behind this likely was some people are interviewing for jobs where you may not have that. It's going to be $25 to $30 per hour, right? It's hard sometimes to say what the company reasonably expects to pay for the position, and there's some there's some discrepancy in how that could ultimately shake out, and the applicants that are coming in the door, that kind of thing. So it's a good faith estimate. This really gives employers a little bit more discretion and good faith ability to say, this is our estimate, right? Now, I will say this, though, just real quick at a higher level. I've seen cases where employees are hired and exactly how much they're going to get paid or the formula or something like that is not 100% clearly defined. And that is a very tricky situation to get in. So it's a fairly rare occurrence, but I usually advise employers that if they're not going to use some kind of written employment contract, which is not usually applicable or not even necessarily a good idea for a lot of positions, it is a good idea to have a hire letter where it lays those things out, where the employee signs off on it. So it's 100% clear after what the person was supposed to be paid. SB 642 is payment of wages. This is Labor Code 1197.5, which is in current law. This is the gender discrimination pay law, and it basically says that employees of the quote unquote opposite sex cannot be paid different rates for substantially similar work. There are certain exceptions to this. This law is going to change the language of that statute from opposite to another sex, and will define wages as all forms of pay, including salary, overtime pay, bonuses, stock options, profit sharing, bonus plans, life insurance, a whole list of things that could be considered a benefit of some kind, a bonus or compensation, right? So a clear example, you have, 3 men, 3 women in a position of vice president, and the salaries are all the same, but the men have, all these bonuses attached to what they're doing, right? That on its face is going to be something that is likely a problem. I say on its face because there are exceptions to this statute, and those exceptions also apply to the changes that are coming in this statute. The exceptions are generally bona fide factors, right? If everybody of a certain gender or sex has advanced degrees, right, or is billing far more hours, or things like that, that the employer can defend as a bona fide requirement. This is why we are compensating the way we are, right? That is an exception. The law does not prohibit that. So I wanted to make that clear to everybody. There are exceptions to this. They all focus on showing that we have a good faith, business related, justified reason to do this. SB 46. Yep. Mm-hmm.
A quick question between the previous slide, SB 642. Does this apply to independent contractors?
It doesn't. The labor code for the labor code, other than very limited exceptions, does not apply to an independent contractor relationship. If somebody is a true independent contractor, in California, you have the ABC test. There are 3 factors to look at. I won't go into detail with them, but the real takeaway is it's hard to make somebody an independent contractor. There are certain stated exceptions. For example, if you're a physician, if you are a lawyer, there's certain professions where those can be made independent contractor. Everything else, if there's no exception to it, you've got to run it through the factors. One of those factors is the work the person is doing cannot be the core of the business, right? If you are a marketing company and you hire somebody to do marketing, that person's very likely going to be an employee if they don't fit in a specific exception. There is also, I will say, an exception for a quote unquote business to business contract. Those can be a little tricky. If you have a situation that meets all the factors for the business to business exception, it's sometimes possible to make somebody an independent contractor. It generally has to be a situation where it really is a business, right? For example, our firm, we use an IT provider. They're a small company, but they are not doing what we're doing. They're really their own separate business. So there's exceptions to independent contractor status. It's tricky in California, and it's become harder to make somebody a contractor.
Do all these SBs apply to companies with fewer than 20 employees?
Yes, everything we've gone through so far will apply to those companies. There are certain, and we're on one right now, where this SB only applies if you've got 100 or more employees. So there's, the ones, for example, the minimum wage, yes, very much so applies to every company. The labor commissioner notice, the template they're going to put out, that applies to all employers too. It varies by the statute that you're talking about. And there are a handful of laws that only apply when you get past, let's say, 50 employees or 100, sometimes 500. Yeah. So this is pay data reporting. Private employers that have 100 or more employees have to submit an annual pay data report to the Civil Rights Division that includes the number of employees by race, ethnicity, and sex in 10 specified job categories, the number of employees by, again, those protected categories whose pay falls within federal pay bands. Within each job category, the median and mean hourly rate for employees having any combination of those characteristics, and the total number of hours worked by each employee counted in each pay band. So this requires some work putting this data together. Again, it's for a company that has 100 or more employees. And I've had clients that have had to do this, and sometimes there can be some nuance as to how these things are calculated. But that reporting has to be done. And I have seen the Civil Rights Division send out notices sometimes if they are not done, especially for companies that have done it in the past and then don't do it. This reporting for the companies to which it applies will be due each year. The next reporting would be May 13th of next year, on the second Wednesday in May each year thereafter. And this is what it looks like. It's the Civil Rights Department Pay Data Reporting Portal. You can go online, Google that, and it will lead you right to it. And it's a online interface.
Derek, when is the number of employees calculated? For example, if you only had over 100 employees for 1 month in the year, does that count towards this?
You know, that question depends on the statute at issue, and I honestly don't know the answer to it for the pay data reporting. I'd have to look at the statute. Sometimes the statutes are unclear on, how you count the 100 employees. But if it only went above 100 for a certain point in time, then I don't know the answer. I'm sorry for this specific issue. Whoever has that question, I'm happy to look into it further. It won't take long. So if you want to follow up with an email after, I'm happy to take a look at the statute at issue. There's also additional changes under 464 for this law. Any demographic information which is collected and stored separately from the personnel records. So we just talked about personnel records and putting things in them. This one, the law expressly says this demographic information is not going to be in the personnel records. Makes some sense. A court may impose civil penalties of up to $100 per employee if you fail to file the required report, and $200 per employee for a subsequent failure. It used to be something where the Civil Rights Division could do that. Now they have to. Anytime you see shall in a law, it means the court or the government agency involved has to do it. Beginning January 1st of 2027, the number of job categories an employer will be required to report on expands from 10 to 23. So that brings in a lot more different jobs, a different analysis of it, and obviously different data that needs to be reported. SB 261 is unpaid wage judgments. There is a new Labor Code statute, 230.05, that says if a final judgment arising from non-payment of wages for work performed remains unsatisfied for more than 180 days after the time to appeal therefrom. The time to appeal is usually, in most cases, 60 days after a judgment or order. So you got 60 days plus 180 days if there's a wage judgment, and there's no appeal of it. There's a civil penalty against that employer not to exceed 3 times the outstanding judgment amount, including post-judgment interest then due. So the effect of this is you could be looking at some pretty substantial civil penalties from this. Let's say there's a labor commissioner matter and it's a $35,000 award to the employee at issue. That's probably a larger judgment from a labor commissioner for a single employee. But you're talking about up to 3 times the amount of that judgment, including the interest, if you go past that, again, 180 plus 60 days. Really, I mean, I guess it's obvious the import of this is the legislature wants those judgments paid. There are a number of outstanding wage type orders and judgments that companies don't pay. I will say in the majority of the cases, those companies are not not operating anymore, but certainly for ones that are wanting to continue to operate, this is something to be aware of and to take care of. This same Senate bill also states that courts shall assess the entire amount of the penalty, except to the extent the court finds the judgment debtor is demonstrated by clear and convincing evidence good cause to reduce the amount of the penalty exists. The penalties assessed pursuant to the section are to be distributed, if collected, 50% to the employee or employees and 50% to the Division of Labor Standards Enforcement. SB 648 is gratuity law violations. So this is tipping laws. Labor Code 351, this is already current law. An employer can't take any portion of a gratuity or a tip paid to or left for an employee by a patron, or deduct that amount from the wages. You can't offset wages against tips or gratuities. I think most employers know this. Where companies sometimes get in trouble is with tip pooling arrangements, which is a fairly common thing in the restaurant hospitality industry. There is going to be a subdivision added to this labor code section that's going to now allow the labor commissioner to investigate and issue citations or file civil actions for gratuities taken or withheld in violation of this section. And really what this means potentially is the labor commissioner could file lawsuits against companies, either for an individual employee or a group of employees, if there's some kind of violation of that section.
Can you expand a little bit? You talked about tip pooling. So a question came in, can a company operating in the hospitality industry still require tip pooling? Or can you clarify that?
Yeah, tip pooling is still valid. It's a complicated area of law. Tip pooling, the idea is, again, you'll see it in restaurants a lot, where the food server is the one that the cash or the credit card tip is left for, but the business has a policy that, hey, you have to split it in these percentages with the busser, with the runner, sometimes with the back of the house staff. Those are still valid. Those are still valid. Those policies, those arrangements, they have to be fair. They have to be, on something. You couldn't say that the food server gets to collect 10% and back of the house gets 90%, right? Something like that on its face is going to be a problem. The other issue that you sometimes see is with tip pooling, anybody who's in a management position of any kind cannot share in those tips. There is some ambiguity over who's considered a manager for purposes of that law, for purposes of tip pooling, because some managers also help out a lot with service at a restaurant or whatever type of business. My general advice for clients is, if that manager has any kind of real managerial authority, meaning they can hire, fire, discipline, even recommend those types of things, take some kind of supervisorial authority over employees, they should not be sharing in tip pooling. So tip pooling can be tricky. I've seen it be an issue for clients. If you have a business that uses tip pooling, it's not a bad idea to have it just looked at by an attorney or even an HR employment type company. For example, as a Silver's HR or companies like that will go in and essentially do an audit of the practices that the business has. SB 809 is construction trucking employer amnesty. So this is an issue of misclassification. We talked about it's hard to make people independent contractors. There is a limited exception for a construction contractor. They can be relieved of all liability for all statutory and civil penalties associated with making somebody an independent contractor who is a driver, if the contractor executes a settlement agreement with the labor commissioner by January 1st, 2029, where they agree to properly classify all drivers performing work on its behalf as employees. There are fairly nuanced procedures for how this has to work. It's set forth in Labor Code 2705.9. But there are certainly companies within the construction industry that this will be a benefit for, that they should take advantage of by January 1st of 2029. AB 288 is the expansion of PERB to private sector. So this assembly bill, the gist behind this is California is concerned about the federal National Labor Relations Board and thinking that the National Labor Relations Board is not doing a good job of protecting employees and advancing what the NLRB should be doing. So what California has done is said that our Public Employment Relations Board, which is up to before this point for government workers, for public sector workers, will now be able to exercise jurisdiction as to private companies. This is a broad idea. How this shakes out at the end of the day, we don't quite know yet. The National Labor Relations Board deals with various things. The most germane would be employees going on strike, employees getting together and protesting working conditions, pay, time, things like that. It can apply all the way down to simply a group of employees texting each other about employment-related issues. There's a broad array of quote unquote unfair labor practices that the NLRB is supposed to have jurisdiction over. Again, this is California saying, well, we don't think that's working, so we are going to allow PERB to take over that jurisdiction. I would assume that this is going to have challenges potentially as to violation of, separation of federal and state authority. I think it's going to get challenged. How it shakes out at the end of the day, we just don't know yet. So under this new law, any employee, again, we're talking private sector, can petition PERB if they've been employed in a position that would have been subject to the NLRA, the National Labor Relations Act, but they lose coverage because the NLRA is repealed, narrow, or enforcement enjoined. Again, on a federal level, the current administration has not been favorable to the NLRA. And so, again, California is saying, if this would have applied to you, you can petition PERB. And the worker has to be employed in a position that would be subject to the NLRA, but the NLRB has expressly or impliedly ceded jurisdiction. There's 4 instances when the NLRB would be deemed to have ceded jurisdiction, which includes processing delays, resulting in the case pending for more than 12 months without the issuance of a final decision. So if they're just not doing anything, not taking action fast enough. Yeah, I'm sorry. There are other instances of that, which I didn't include in here, but the most germane one when I looked at that assembly bill was simply the NLRB not taking action. And at that point, the employee in the private sector could go to PERB. I will say broadly, because the NLRB's authority is so broad, for the most part, employers in California haven't really needed to worry about it. But if PERB takes this up and starts issuing enforcement type actions and becoming active in this area, this could change a lot of things for employers. SB 590 is expanded paid family leave benefits. So starting July 1st, 2028, PFL will now include benefits for individuals who have taken time off work to care for a seriously ill designated person in addition to a family member. Designated person is any care recipient related by blood, here's the kicker, is or whose association with the individual is the equivalent of a family relationship. So these benefits are going to apply if there's anybody that's being taken care of. It doesn't have to fall under the normal family type relationships. It can be a person whose association is the equivalent of that. It will require the employee seeking benefits for this designated person to take care of them, to identify them at the time of the first claim, and under penalty of perjury, attest to how this relationship is blood related or the equivalent of a family relationship, right? It's, I was raised by so-and-so, they're not my blood relative, but they've always, acted in that regard. A person is going to fall under a designated person. This is just an outline. A good deal of this was generated by AI, which is a nice benefit to all of us, I think. At this point, these are just some time frames going over some of the things we looked at here, things that employers should be doing. So doing it now before the start of next year, under the key activity, it's things that the company can be doing. Again, update your payroll for the minimum wage raise. Make sure you don't have any contracts that are going to be a prohibited stay or pay clause. Again, that prior contracts, not worried about them. But companies, have contracts that they typically use going forward. Make sure if those fall under that law, they're not being used anymore. Audit the gratuity tip practices if that's part of the business. Update job postings, pay scale disclosures, and if it applies, begin preparing the pay data reporting. By February 1st of next year, the template we talked about should be out. Distribute the Know Your Rights notice, incorporate it into all the new hire packets. By March 30th next year, collect the emergency contact designations that are needed and the notification process if you have an employee arrest detention situation. Throughout 2026, certainly for employers that operate in multiple jurisdictions, counties, cities, monitor the local minimum wage ordinance changes, because every time we have a state minimum wage increase, you will often see specific jurisdictions increase theirs as well. Again, if you have a company that operates throughout Northern California or all of California or on a US basis, it's important to know, certainly for California, and I would say certainly when you're getting out into the Bay Area, are there specific, not just even minimum wages that apply, but specific local jurisdiction laws. If you have a situation where the WARN Act applies for layoffs, make sure those notices are including the new information. Continue audit of pay data and wage theft exposure. Planning for 2027, prepare for the expanded pay data categories going up to 23, the PFL eligibility expansion, and remain aware of future legislation. I added some additional things here. For all of this, review your employee handbook, policies, update it as necessary, update job postings. I put this in because it's important. We continue to see a lot of wage and hour actions, PAGA, which is Private Attorney General Act, sometimes in combination with a class action wage and hour. Those can arise easier, I think, unfortunately, than most companies understand. But if you're talking about a class action wage and hour, meaning, hey, this group of employees did not get paid for meal periods, they didn't get proper overtime, look at implementing an arbitration agreement with employees. Those can be a very strong defense. They're not going to get rid of a class action entirely, but they give the employer some significant leverage if you're faced with a class action. They do not apply to PAGA. PAGA is a little bit of a different beast where it's an action by the state, really. But the gist of an arbitration agreement, there's complexities to this, but the gist of it is, if an employee sues as a representative for a class and they've signed a valid arbitration agreement, which the laws on that change pretty frequently, but if they've signed an arbitration agreement with a class action waiver, they can be compelled to take their individual claims into arbitration with the employer on a one-on-one basis, and they don't get to act as a class action representative. So it breaks up a class action into one arbitration. There's complexities to it. If you have an employee that hasn't signed these agreements, it doesn't apply. But again, the takeaway is that can be a very powerful defense. I would also say conduct sample payroll and or HR audits. Do it before there's a problem. It really goes to this, and that's why I brought this next slide. PAGA is Private Attorney General Act. I think a lot of people have heard of it. The gist of it is it's much like a class action. It can be one employee who has suffered labor code violations and brings an action to sue for the penalties associated with those labor code violations for every employee at the company. It just takes one person really to start it. They are usually very devastating and time consuming for employers. The reason I say do these audits ahead of time, and it doesn't have to necessarily be an audit of every single employee if you have 150 employees. It can be samples, random samples, right? The idea is you want to get a sense, Are there problems with pay? Are there problems with breaks? Are there problems with time? And again, there are companies that can do it. Law firms can do it if they're in employment, if they handle employment law. Companies like Silver's HR, companies that do HR practice review, they can do it as well. The reason being, PAGA penalties, and PAGA only recovers penalties. They're capped at 15% for an employer that demonstrates that prior to receiving any PAGA notice or request for employment records from a PAGA plaintiff, right? So that's a little bit tricky because they just have to have an attorney or an employee say, give us the records. If a company prior to that happening has taken, quote unquote, all reasonable steps towards complying with the labor code, then the penalties can be capped at 15%. And if the employer can show that in a PAGA type lawsuit, it's very powerful evidence, because it means that even if the plaintiff wins, if that defense is clean, whatever they get is going to be 15%. So it's substantially reduced. If you're doing these audits, make sure meal, rest breaks, overtime, and payment of wages is 100% clean, and there's proof of compliance. I say that because the one tricky area you sometimes see is it's very hard to keep track of rest breaks, right? People don't clock out for them. So how do you prove it a year later? You have 50 employees that say, well, we didn't get rest breaks a year ago. It gets into people's memories. It gets into just the credibility of people involved. Develop some kind of a system. There's all sorts of ways of doing it, of having the employees verify that they've taken all breaks each time. It's a powerful thing to be able to produce records that show this person saying, I attest that I have taken, XYZ, and signing off on it each time for each pay period. Another thing I would say, I'm sorry, go ahead.
A question came in. Do you know of any exclusions to the Brinker law for surgical assistants, health care workers that are hourly?
So Brinker versus Superior Court is a California Supreme Court case that in general, and I probably need a little bit more information on the question, only because Brinker, generally the holding of it is, and I will say cases say a lot of different things, and there's also just what the holding is, which is what you can really rely on. Brinker is usually a pro-employer case because it says you don't have to police the workforce. You don't have to force people to take breaks. You just have to let them know they can do it. You have to encourage them to do it, and you have to not dissuade them from taking a break, at all. So Brinker is usually a case that employers say, hey, if you didn't take a break, it was on you because we did everything we possibly could have to get you to take it. So Brinker, again, I probably need a little more clarification on the question, but Brinker is a case law, so it really applies to all employers. I will say there can be nuances for breaks for each industry and also for each wage order. So one thing to do is whatever company you work at, if you're in HR or you're looking at these issues, make sure you know the wage order. Those can be found online that applies to your industry, because that will cover the specific meal and break laws. For the most part, they're very similar, but they can have some nuances to it. And I know I probably didn't answer the question, so if there's more on that question, I'm happy to try to answer.
Perfect. Yeah, well, maybe we'll have the person reach out for some more clarification on that one. In addition, somebody asked, what's the best way to document the rest breaks? Like, do you have any recommendations on that?
Yeah, I usually ask clients what they're currently using, right? And by that I mean there's still some companies that are doing, punch cards. There's still some companies that are doing handwritten type time records. If the company uses a electronic pay system, which in most cases is the best, I've seen it can depend on the pay system involved, right? And so some of it can be making sure you've talked to that company, whether it's Paychex or Paycom or whoever it might be, to find out what options they have available to track rest breaks. We've represented franchisees where the timekeeping system they used is a proprietary type of thing, for example, a Domino's Pizza or something like that. And those systems will sometimes have pop-ups reminding people to take their breaks, or they will have some kind of a electronic verification by the employee that they have taken their breaks. So it really depends. And I say that only because we have construction clients where, hey, they're not going to have, some kind of a portal where people can just, clock in electronically every time because they're on a job, so a lot of it is really working with the employer to find out how things work currently. Where are the employees? Are they in a warehouse? Are they out in the field every day? Are they driving around from site to site? My usual push for a lot of employers is get a really good electronic timekeeping system, right? And some of those can come with apps where the employee can clock in, clock out, make changes to things right there on their phone, so if it's something like that, I've seen electronic timekeeping systems where it will require some kind of a little checkbox or some kind of a verification when time is submitted each pay period to say, I have taken all rest breaks. Barring that, if it has to be, it's not a bad idea to have something in writing that's properly drafted, that's very clear, that, a year later, if a judge looked at it, they would be able to see, hey, it's very clear what this person's saying. For this pay period from this date to this date, this person has taken all of their rest breaks. They understand they're entitled to rest breaks. It's usually good to include meal break language in there as well, even though meal breaks should obviously be already recorded in the time. There's different ways to do it. It can be written, it can be electronic. And again, depending on the system you're using, I've seen some situations where a company reaches out to their payroll system and they say, we can actually add that as a function, so yeah, different ways to handle it.
Got a follow-up, I think, to the previous question. Can the requirement to take a lunch break by 5 hours be waived if they are in a surgery and it's not safe for them to leave the operating room?
Yeah, you can. And what I would say is, so I'm going to assume that, if it's a doctor, some of this can depend, right? And it can depend because it depends if the person's exempt. It depends what wage order they're under. So the first thing to do would be make sure you know exactly what the wage order is saying, exactly what it's saying as to meal and rest breaks, whether or not the employee is exempt from overtime, because some exempt positions also have certain exemptions depending on the wage order from meal and rest breaks, right? Like most people know the exempt employee as, well, they're exempt from overtime. There can be exemptions for certain industries for meal and rest breaks in certain situations. And you're talking about a surgical situation. There are standard avenues that employers can use for any kind of an employee where the nature of their job does not allow them to take a rest break, meaning, let's say you have a situation where somebody's the only person on duty, and they just, it's busy, they can't do it. You can do on-duty meal periods in certain situations. I'm assuming with a surgery, that is not going to be something that applies, right? So I would go with the wage order exemption. And again, if you're talking about a physician, you would want to look for the exempt positions for a physician under there, which is under the professional exemption. Find the wage order, find the exemption, find the professional exemption, make sure that employee fits within them. Some of this, requires a little bit of review and analysis to make sure they fall within them, because a physician in certain situations may not be exempt. Well, I'll say it the other way. A nurse may not always fall under certain professional exemptions as easily as a physician, right? Physician is expressly listed under most wage orders as an exempt employee. So see what your wage order says, see if that employee is exempt, and then see what applies under that wage order for those exemptions. That's where I'd start with it, right? So I'll cover this one last, I think it's the last slide quick. I put this on here, train managers, put it on here because a lot of the legal disputes we see involve either primarily or at least to some degree, a lot of times, especially for wage and hour issues, something area where the manager fell down, meaning, and I'm not trying to knock managers in any way, shape, or form. I'm just, managers have a hard job. You know, you can have a company that has hundreds of employees, different stores, different locations. They can have great employment policies. They can have great timekeeping systems and payroll systems, and those will help a lot. But if the company has a manager at a specific store that doesn't know the handbook well enough, or doesn't know the policies well enough, or doesn't apply them well enough, right? Just doesn't keep enough of an eye on them. Managers have a lot on their plate, you know, and depending on how the company operates, there may be an HR head that is doing this. And so the managers have less to worry about with it. But at a lot of companies, managers will hire pay time, will handle pay time and HR type issues to some degree. And so it's really important to make sure they're trained, that they understand these things. The policies won't help much if managers are not applying them, following them. One of the grounds for complying with the labor code under all the PAGA statutes to reduce all the penalties is disciplining managers when they're not doing what they're supposed to. It's baked right into the law. It says it. So you just got to make sure managers know what they're doing, they're trained on it, and they're following it. Yeah. And that is the end. Thank you all for listening and going through this with me. And I think we'll
Thank you, Derek. We really do appreciate you taking the time to educate our audience. And we appreciate your guidance and wisdom here. And so we want to thank everyone who's been on the call, who stayed on a little bit longer. We appreciate you taking the time out of your busy schedule to join us for today's BenderU. As a reminder, while this session has been recorded, and both the recording link and copy of today's slide deck will be emailed to you following the webinar. Should you have any questions that arise after the webinar, please feel free to reach out and we'll be happy to help. I know Derek is more than willing to answer any additional questions that come up after this. Thank you again, and we hope you have a wonderful day.